On 12th of August 2016, you will have to consider how the Insurance Act affects insurance policy claims. This video explains the new duty created by the Act, the duty to present the risk fairly. It follows on from my earlier video, which gave an overview of how the Act deals with non-disclosure and misrepresentation. If you haven't watched that video, then I recommend that you do so now, otherwise you're going to get a bit lost. You should also by now have downloaded a copy of our distinctive booklet on the Act, so that you can refer to it while watching the video. You'll find a link to the booklet on the page where you found this tutorial. Let's get started. Turn to page 3 of the booklet. This should be familiar to you from the previous video. This gives an overview of the Act's approach to non-disclosure and misrepresentation. You recall that the blue rectangles indicate that you have to turn to another page to consider an issue in further detail. This is a key part of the changes brought about by the Act. It concerns an assessment of whether the insured has made a fair presentation of the risk. To answer the question asked in the box, you should turn to page 5. Do that now. Page 5 will help you understand how to assess whether a risk has been presented fairly by an insured. You work through this page just like the previous one, answer each question, and follow the arrows depending on whether the answer is yes or no. Once you've completed this page, you'll know whether there's been a fair presentation of the risk, and whether to answer the question in the blue box with a yes or no. You'll see that the first question that has to be answered is also in another blue box. That is an assessment of whether the insured disclosed information that would influence a prudent insurer. They're only expected to have disclosed information that they knew or ought to have known. The Act calls each bit of information like that a material circumstance. How to assess whether something is a material circumstance that should be disclosed requires some further explanation, so we'll deal with that separately in the next video. But it's important to understand at this point how the assessment fits into the overall duty of fair presentation. It may be that you not even have to assess the insured's knowledge of material circumstances depending upon other information available to you now. So, for the purposes of this video, let's assume that the answer to the question in the blue box is no. The insured is not automatically in breach of their duty. They might have provided some information that falls short of disclosing a material circumstance. You then have to ask yourself whether the information that was disclosed was enough to put a prudent insurer on inquiry. So what does that mean? Well, that's an objective test. You don't need to ask the actual underwriter what they would have done, although you might want to do that, as it will be helpful to give you a steer as to what the prudent insurer would have done. The prudent insurer is a mythical beast. You're really assessing the question against the standard of the market of that particular line of business generally. So you'll have to think through whether enough information has been disclosed that should have prompted a prudent insurer to ask further questions that have caused them to discover the information that has now come to light. If the answer to that question is yes, then you move on to the same question that you would have done if the answer in the blue box was yes. But what if the answer to the question of whether a prudent insurer has been put on inquiry is no? Well, the insurer might still be able to say that they are not in breach of their obligations. You have to consider whether the material circumstance is what I call an exception to the insured's obligations to provide disclosure. There are some categories of information that are exceptions to the general rule. I flag up here to turn to page 11, but rather than go through that, I'm going to give you a quick summary of what the exceptions are. There are 5 exceptions, and the majority are self-explanatory. The insured doesn't need to disclose material circumstance that diminishes the risk. Neither do they need to disclose information that the insurer already knows about. By insurer, you're really looking at the knowledge of somebody who works for an insurance company and who decides whether to take on a risk. It does not mean that just anybody employed by an insurer who might know something about the insured is deemed to have passed on that information to the underwriter. The third type of exception is information where insurers waive their right to it. It might have been offered to the insured by, say, the broker, and the underwriter simply have not been interested at the time. They can't change their mind now. The next category is where an insurer ought to know about a material circumstance. So what we call by that exception? Well, information that falls in this exception is the type where an insurer's employer or agent knows about a material circumstance and ought reasonably pass this on to the underwriter. An example of that might be a surveyor or a medical examiner employed by an insurer or acting as their agent who finds out some information and should be passing it on to underwriters. But also within that exception is any information about a material circumstance readily available to an underwriter. The words readily available are found in the Act. They might create some problems in the future, and there might be situations that challenge what this phrase is intended to cover. For instance, an insurer's database might hold information about an insured, but unless that information is readily available to an underwriter, it doesn't fall within this exception. That seems harsh on an insured, which is why I think they might require the courts to get involved at some point in the future to provide more clarity. Finally, there is information that insurers are presumed to know about. That would be the type of information which an underwriter should know about in relation to the type of business they underwrite. For example, with energy risks, an underwriter may be expected to know about certain types of practices, to do with oil exploration, that are particularly dangerous, and it might be presumed to know that an insured of a certain type will be exposed to such risks. So there are the 5 exceptions that you should consider at this stage. You'll see how this fits into the overall picture of fair presentation in a moment. Let's go back to these earlier questions. Say your answers have led you to this question: was this disclosure reasonably clear and accessible to a prudent insurer? That requires you to look at the way in which the risk was presented. The presentation may have been straightforward in some smaller claims, perhaps it was through completion of proposal form, but for more complex claims there might be a large amount of information to assess. There might be information in there that's technically been disclosed, which has been buried. You will have to consider whether the information is reasonably clear and accessible, again to the judgment of the prudent insurer. This provision was brought in to prevent data dumping, or simply throwing large amounts of data at insurers and expecting them to sort it out. Remember, insurance policies are still contracts of good faith, and it's for the insured to tell the underwriter about the risk, not the other way around. If the answer to that question is yes, then you have to consider whether every material representation as to facts is substantially correct. What is fact and what is opinion are different. Whether a fact is substantially correct is again judged on whether the prudent insurer would think there was any real difference between what was being represented and the true state of affairs. It is a marginal assessment, but it is something which you will have to exercise some judgment over. Again, if the answer to that question is yes, then you move on to the next question. This deals with opinions. Was every material representation as to an insured's expectation or belief made in good faith? In other words, it does not matter if the opinion turned out to be inaccurate, so long as it was honest. We're looking here not at whether a fact is correct or not. There was something expressed by the insured which led underwriters to believe that something was going to happen perhaps in the future, but in fact it didn't. Was the representation that was made that was relied on by the underwriters in good faith? It's always difficult to demonstrate that something has been done in bad faith, but you may be able to focus in on particular circumstances or evidence. If that was material to underwriters' consideration and the insured acted in bad faith, then the answer to this question could be no. However, if there is no such evidence, then the answer will be yes. That will mean you have worked your way through the questions, meaning you've come to the conclusion that there's been a fair presentation of the risk. You take your yes answer and turn back to page 3. Then you need to work your way through the rest of the flowchart until you get to your ultimate conclusion. If, however, any one of a number of questions caused you to find your way to the other conclusion, then you would take a no back into page 3 instead. So once you've obtained your answer, yes or no, on page 5, then go back to page 3 and follow the relevant arrows. You'll appreciate from the previous video that this may lead to an insurer having a remedy against their insured. This has been a close look at a specific part of the Act and how it changes the law in relation to non-disclosure and misrepresentations. You can watch other videos in this series to learn more about the detail of the Act. I'm Michael Hogg, a partner at Kennedy's London office. Insurance Act 2015, a distinctive approach.